Have you ever pondered over the intricate system of marriage and divorce in Islam? Well, today's discourse will delve into the importance of divorce and iddat in Islamic law before a woman can remarry, as validated by renowned Islamic scholars. Let's begin with the words of the esteemed scholar, Sheikh Muhammad bin Salih al-Uthaymeen, from his book, Fatawa Arkanul Islam. He writes in Arabic, لا يجوز للمرأة أن تتزوج وهي في عدتها, which translates to, it is not permissible for a woman to marry while she is in her waiting period. This quote represents the essentiality of iddat, or the waiting period post-divorce, in Islamic law. Moving on, let's examine the profound words of Sheikh Ibn Baz from his book Majmu' Fatawa Ibn Baz. He elaborates, لا يجوز للمرأة أن تخطب في عدتها, meaning, it is not permissible for a woman to be engaged while she is in her waiting period. This reinforces the idea that a woman must complete her iddat before considering remarriage. Now let's turn to the words of Imam Malik from his book Al-Muwatta. He states, لا تنكح المرأة حتى يطهر منها زوجها, which translates to, a woman may not marry until her husband has divorced her. This quote emphasizes the importance of divorce as a prerequisite to remarriage in Islam. In the same vein, Sheikh Ibn Uthaymeen, in his book Sharh Riyad as-Salihin, published in the year 2003 in Makkah, asserts, لا يجوز للمرأة أن تتزوج قبل أن يطلقها زوجها, meaning, it is not permissible for a woman to marry before her husband divorces her. This quote further strengthens the argument for the necessity of divorce and that before a woman can remarry. In this segment, we will delve into a comparative analysis of women's rights in divorce under UK civil law and Islamic Sharia law. This analysis will enable us to better understand the nuances in both legal systems. Beginning with UK civil law, let's consider the words of renowned family law barrister Elspeth Thompson. She says, in the UK, the law strives for fairness in divorce. Both parties have equal rights to file for divorce, and the division of assets is usually equitable. This statement encapsulates the essence of UK civil law's approach to divorce. Switching gears, let's examine Islamic Sharia law's stance on the matter. The Quran, in Surah Al-Baqarah, verse 229, states, الطلاق مرتان فإمساك بمعروف أو تسريح بإحسان, meaning divorce is twice, then either keep in an acceptable manner or release with good treatment. This verse emphasizes the respect and kindness that should be accorded to a woman during divorce proceedings. This principle is further explained by the esteemed scholar Sheikh Salih Al-Fawzan. He writes in his book Al-Mulakhas Al-Fiqhi, Al-Maratu laha huquq fi talaq kama lirrajul, which translates to, a woman has rights in divorce just as a man does. This statement underscores the equal treatment of men and women in the context of divorce in Islamic law. Thus, both UK civil law and Islamic Sharia law aim to uphold the rights of women in divorce. Each system, while different in practice, strives to ensure fairness and respect in the dissolution of a marriage. Stay tuned as we delve deeper into this topic in our next segment. In today's episode, let's wander through the labyrinth of divorce rights of women under both the UK civil law and Islamic Sharia law. The UK civil law, in its judicial outlook, provides women with the liberty to initiate a divorce and guarantees a balanced division of assets, reflecting the contributions made by both partners during the marital journey. Switching our focus to Islamic Sharia law, we find the Quran emphasizing respect and benevolence towards women amidst divorce proceedings. The in الطلاق مرتان فإمساك أو تسريح بإحسان, meaning divorce is twice. Then either maintain in an acceptable manner or release with good, embodies this principle. On top of this, the renowned Islamic scholar Sheikh Salih al-Fawzan interprets al-mar'a laha huquq fi talaq kama lirrajul to mean a woman has rights in divorce just as a man does. This accentuates women's unique rights during Islamic divorce. Our journey doesn't end here. We come across hadith as narrated by Abu Dawud in his work Sunan Abi Dawud, published in Riyadh in 1990. The Prophet Muhammad, peace him, is quoted saying, Atun nisa sadaqahun nahla, or give women their dowries freely. This hadith puts the spotlight on a woman's claim to her dowry should a divorce occur. To wrap it all up, both the UK civil law and an Islamic Sharia law acknowledge and safeguard women's divorce rights. The comparison we make today aims our viewers understand the comprehensive rights of women in divorce under these two contrasting legal systems. In summary, the teachings of these esteemed Islamic scholars unequivocally convey that in Islamic law, a woman must be divorced and complete her iddat before she can consider remarriage. In addition to this, we will also reflect on a comparative study of women's rights during divorce under UK civil law and Islamic Sharia law. This concept goes beyond mere legality. It is about respect, honor for the institution of marriage, as well as the rights and dignity of women. Sheikh Salih al-Fawzan, a prominent contemporary Islamic scholar, puts it aptly, الزواج عقد شرعي يتعلق بأمور الدين والدنيا, meaning marriage is a legal contract that concerns matters of religion and life. It is a sacred bond, not to be taken lightly, and each step in its dissolution and renewal must be treated with the gravity it deserves. This enlightening journey through the teachings of renowned Islamic scholars, coupled with a comparison of legal systems, is a testament to the wisdom and foresight of Islamic law, which always aims to uphold justice, honor, and respect, especially in matters as essential as marriage and divorce. Do not forget to click on the like, subscribe, and share button. In the aftermath of a divorce, another complex issue arises, the division of property. The approach to this differs considerably between UK civil law and Islamic Sharia law. As we delve into this topic, we will draw upon the wisdom of professionals, renowned Muslim scholars, and sacred Islamic texts. In UK civil law, property division post-divorce is typically settled based on equitable distribution. This means that all marital assets are divided fairly, but not necessarily equally, taking into account each party's needs and contributions. However, in Islamic law, the scenario is quite different. The Quran states in Surah Al-Nisa verse 32, وَالْرِجَالِ نَصِيبٌ مِمَّا اكْتَسَبُوا وَلِلنِّسَاءِ نَصِيبٌ مِمَّا اكْتَسَبْنَ, which translates to, for men is a share of what they have earned, and for women is a share of what they have earned. This principle is further supported by hadiths emphasizing that what a woman earns and owns remains hers, untouched by the claims of her husband or any other family members. Renowned Islamic scholar Dr. Jamal Badawi, in his book Gender Equity in Islam, published by American Trust Publications, 1995, Indiana, USA, further elucidates this point. He states in case of use this divorce, she is entitled to the full payment of her mahar property and gifts given to her and to alimony during her waiting period, iddat. In essence, the division of property in Islamic law is based on principles of justice, respect for individual earnings, and protection of women's rights. It illustrates the depth and wisdom of Islamic teachings, ensuring that even in the distressing situation of a divorce, fairness prevails. Do not forget to click the like, subscribe, and share button.